Our third and final case this morning is Homespace versus Airbnb. Are you reserving 3 minutes?
Yes, 3
Okay,
minutes, please.
thank you.
May it please the court, I'm Lindsay McElrath for Homespace. And so the underlying case in this matter is a suit brought by Homespace under the Washington Consumer Protection Act, solely seeking an injunction against Airbnb to protect the public.
Right, so four Airbnb entities.
For Airbnb entities.
And the
Homespace.
plaintiff was Homespace
That's correct.
in the Superior Court.
In the
Yeah,
Superior
so
Court.
go ahead.
And the action sought the only remedy the action sought was an injunction against Airbnb to protect the public. We know that injunction would protect the public because the CPA, the Consumer Protection Act, requires public interest as an element of any injunction that issues.
So the complaint morphs and breaks apart. It becomes three demands for arbitration. One, and they're all, the plaintiff now goes from being Homespace to McElrath. And the respondent now is Airbnb Travel, Airbnb Inc., and Airbnb Payments.
Yes.
So why and how is that happening?
Yes. So the Airbnb moved to compel Homespace to arbitration using an agreement with McElrath. So McElrath is in privity with Homespace, and Airbnb argued that Homespace was bound to the arbitration agreement through its agreement.
And then why break it up?
Why break?
Why break it up into three demands for arbitration?
The arbitration agreement includes a clause that says that it only allows bilateral arbitrations. So each were filed in an attempt to comport with that requirement.
Mm-hmm.
The other arbitrations were held in abeyance
Right.
pending the resolution of the first
Travel
arbitration.
moves forward.
Travel was the first one to move forward just based on the timing of the arbitration.
Okay.
That one moved forward. The other ones did not even have an arbiter assigned to those cases. And once the travel arbitration completed, the other arbitrations have nothing to do with this
Yeah,
case.
they're right. They have nothing to do. So go ahead. I didn't mean to.
And moreover,
divert.
the standard of review for this case is constrained to the face of the arbitration award. So obviously, other arbitrations and other matters are far outside of the face of the award in this arbitration.
Right.
And
So when we look at the face of this, the problem we have is this language that says, while the terms of service designated California law be applied, comma, the arbitrator believes the proper interpretation should be based on the ordinary meaning. And the narrow question, as I see it, is why is that not a disavowal of the applicability of California law?
And that was somewhat inarticulate wording by the arbiter, but basically the arbiter was adopting Homespace's position there, that McGill, it does not control the interpretation of a private agreement. If you look at the McGill case, it is not a case about contract interpretation. It is a case about a set of claims that cannot be compelled to arbitration. Here, we have a private agreement that used the words public injunctive relief. California law is clear that in a private agreement, the ordinary meaning of the word.
So you're asking us to dial in on ordinary meaning because it's sort of a magic phrase in California case law. Like in Washington, we have the plain meaning rule. And in California, they have the ordinary meaning. It's a statute.
Yes, it's a statute, and that statute says not only ordinary meaning, but that you do not necessarily use the legal definition of a term. So
Right,
it
so we have to
explicitly
read
calls
into it, right?
Read into the
Well,
statute?
no, not read into the statute. So when I look at this and I see that phrase, ordinary meaning, to me, it evokes California statutory law.
Yes.
And I know, at least I believe I know, what the arbitrator meant by that phrase.
Right.
But to confirm that, I need to go research California case law.
No,
So
you-
am I going beyond the four corners?
No, you do not need to research. That's exactly it. The California case law is extrinsic to the agreement itself. So the agreement, you look at the four corners of the agreement to determine, or the arbiter looks at the four corners of the agreement to determine the meaning of the word. California law says there's either ambiguity in those
Yeah,
words.
I'm on a different issue. I'm talking about the four corners of the award, the face of
Yes.
the award.
Okay.
Yeah.
So if you look at the four corners of the award itself, it does not say that McGill is controlling precedent, that McGill controls the interpretation. In fact, it says the opposite. Even though McGill uses this phrase, that is not controlling. That's what the arbiter is trying to say in his award. And
So we're not going to follow McGill. We, the arbitrator, are going to instead apply the ordinary meaning.
civil code of contract
Can we
interpretation.
determine from the use of those, what I call magic words, that the arbitrator is indeed still applying California law, but in this particular instance, it would be the statutes that require consideration of the ordinary meaning?
Yes, you can. I think the arbiter, if you look at the arbitration award in whole, it's clear that the arbiter is looking at California law in whole. The arbiter mentions the fact that the agreement should be construed against the drafter. He mentions the fact that an ordinary consumer would not expect a narrow interpretation of the arbitration award. And I've cited cases in my briefing that show that in California, in a consumer context, a contract should be read against the company that drafts it. I think that's
Yeah, except
elite
you're
insurance.
focusing on the contract, and I'm focusing on the award itself.
Okay.
And I'm not sure that there's any presumptions that we presume the award is valid or we presume the award is invalid. We just look at the face of the award and see if it complies with whether they've exceeded their authority by disregarding the law. But let me ask you a different question before you go. Let's assume that we get past the issue of confirm the award or vacate the award and we reverse. So we send it back to the trial court to confirm the award. Why wouldn't an order confirming the award be limited to travel?
Your Honor, there's 2 points there. The first point is that the arbiter's remedy is subject to the same standard as the award itself. So the remedy, anything that the contract allows him to give as a remedy is fair. Second of all, standard principles of privity and equity would bind the other entity. So even if you conform it.
That's not really before us. We have no record on alter ego.
Right, but you have no record to the contrary. So
piercing
you would look to the
corporate
face
veil.
of the award to see if there's anything to the contrary. And I believe the arbiter does say that all of the entities are before him that are needed. And that if you look at paragraph 29 of the word, page 218, oh, sorry. Maybe I should come back
18.
to
You're talking about 18?
paragraph 18, yes. Although he finds that all of the entities are bound by the same arbitration agreement. And so if you look at the case law, it clearly says that the arbiter has the ability to exercise his authority that is given to him through the contract against all of the entities that were before him.
I thought you had said, and you can answer this when you come back, that you were required to bring them individually, make them bilateral.
Yes, Airbnb did not take that position in the arbitration, so they came forward, they said they represent Airbnb Inc. actually came forward in the case against Airbnb Travel and said that Airbnb Travel is actually erroneously named. Airbnb asserted the defenses of all of the Airbnb entities using agreements with other Airbnb entities. And so that's where the equity comes in, that Airbnb cannot go through an entire arbitration knowing full well that, this was the issue, the case below was the issue, and that all of the entities were at issue. But then after they get the award, say, oh, actually, sorry, this whole arbitration was for nothing. There's no, the arbiter does not have that authority.
Thank you.
Good morning, Your Honors, and may it please the Court, Katie Bass of Ballard's Bar here on behalf of Airbnb Respondents. This case presents a simple issue, whether an arbitrator's refusal to apply the California Supreme Court's definition of public injunctive relief when determining whether a claim is arbitrable constitutes an error of law on the face of the arbitration award and justifies vacating that award.
you've defined that issue very narrowly. The choice of law provision doesn't say California's Supreme Court decision. It says California law. So California law is made up of a lot of different decisions by several different courts, but also statutory law. And in California, unlike in Washington, there's statutes that govern contract interpretation, and they use this magic phrase, ordinary meaning. So again, when I look at the arbitration award and I see that phrase, I understand that, or at least I can understand that, as being a specific reference to California statutory law. And then I, kind of accepting your argument, what I see is that probably a better way to approach this from the arbitrator's standpoint would be the arbitrator writes, the arbitrator believes the proper interpretation should be based on the ordinary meaning of the phrase as understood by a consumer, comma, as required by our statutes, comma, rather than a more restrictive definition. And if the arbitrator had written that, I don't think we'd be having this discussion.
Your Honor, I think in order to get to the construction that you have articulated, we'd have to look past the Federal Arbitration Act, which indicates that we have to look to the face of the arbitration award.
Well, I'm looking at the face, and I see this magic language, and I think I know what it means.
I think that to get to that, we would have to read into the arbitration award language that simply is not there.
There's 3 words.
I agree, Your
Required
Honor.
by statute, 4 words.
However, that is not how the arbitrator framed their award. And additionally, this arbitrator, in order to get to that construction, said the California Supreme Court has defined this remedy, this public injunctive relief, in this specific way, and in order to construe the statutes.
In a slightly different context. I mean, the cases are not, the McGill case is not directly on point.
The McGill case relates to consumers who have an agreement related to a consumer credit card, so I think that it does speak to this remedy. And the fact that the parties in this arbitration agreement adopted California law includes California case law.
Sure, it does, and it includes the statute.
And
So we see a very express reference to McGill, and then we see this language, ordinary meaning. And we can either assume, I'm not sure that's the right word, that ordinary meaning is just 2 words that the arbitrator picked up randomly, or we can take into account that it's a statutory standard, which is consistent with case law and the statute, which one can argue takes precedent over the Supreme Court's decision in McGill.
I think we would also have to assume that the Supreme Court in McGill was aware of ordinary meaning and knew that this phrase would have ordinary meaning when they were issuing this ruling.
They weren't really interpreting a contract there. They were, applying their case law on the scope of relief available under, I think, 3 statutes. So it's a slightly different issue.
Slightly different issue, but I think issued clear direction to courts to businesses applying California law to their arbitration provisions, that it cannot be a uniform arbitration provision requiring consumers to arbitrate requests for public injunctive relief. So in that event, Airbnb, a California-based business applying California law to its arbitration provision, has no choice but to exempt public injunctive relief from its arbitration provision. There's no way to do so and define that phrase in the contract in a way that will keep up with California case law other than to incorporate California case law. The arbitrator was not free to ignore that California case law, as it's clear that he has done here. He says, this is what the case law is. If I take the McGill definition, as well as progeny, it is not simply McGill. McGill was recognizing public injunctive relief in prior California cases, saying, if I look to California case law, then Homespace's complaint.
Case law, right. But then, so the other words, I guess, that are not there are, McGill is distinguishable.
Right.
Okay, well, if he said McGill is distinguishable, so therefore I rely on the ordinary meaning in accordance with California statute, and then he cites it, again, we wouldn't be having this discussion. It seems like there's a few words missing, but even when one focuses, as we must, on the face of the award, we can see California statutory law pushing forward.
Respectfully, Your Honor, I think you're doing a lot of work for the arbitrator that
Okay.
the arbitrator has not done.
So let's assume you're right, I'm doing too much work for the arbitrator. It seems like we as a panel have 3 choices here, not 2. One is that we can reverse and we can say, We can discern California statutory law on the face of the document, and so we disagree with the notion that the arbitrator has disavowed California law. We can affirm. And there's a third option that the parties don't address, which is there's case law in Washington that when you have an award that is unclear on its face, we can send it back to the trial court to seek clarification from the arbitrator. Why shouldn't we do that here, given the tenor of this argument?
I don't believe that this award is unclear on its face. I believe that it contains a
Right,
clear.
your opposing counsel says it's also not unclear on its face, and he says it means exactly the opposite.
I understand,
So we
Your
have
Honor.
two plain meanings, right?
That happens a lot here, by the way, just
Yeah.
for the record.
Is the problem that the arbitrator said too much and tried to sort of half explain the reasoning, maybe? Because we wouldn't, I guess I'm stuck on what makes it facial versus they have the authority to interpret and to decide what the law is and then to apply it. That's the authority that the agreement gives them. And we're really not supposed to touch that unless there's a facial legal error.
I believe that the error is facial and clear here. I don't believe the problem is that the arbitrator said too much. I believe the problem is that in explaining the arbitrator's reasoning, there is a clear error. I think any articulation of this result necessarily involves the arbitrator disregarding California law interpreted as interpreted in case law and directed by case law.
So, I agree with what you said until I recognize, as I think we have to, that ordinary meaning is a magic phrase. And it only comes from one place. It comes from the statute. So it seems like, Judge Chung is right, this arbitrator either said too much or too little. And either way, we're sort of stuck trying to figure out what it means. But where can ordinary meaning come from other than the California statute?
I think it was up to the arbitrator to articulate if that was their basis of reasoning and make a reasoning that on its face complies with California law, that when a Washington Superior Court or yourselves are reviewing the face of the award, they had the basis that the arbitrator relied upon to determine whether this contained an error of law. The arbitrator failed to do so, and the error of law, I believe, is clear on the face of the award.
Didn't McElrath specifically argue for the ordinary meaning consistent with the statute as a predicate to this award?
I believe so.
Okay, so can we consider that?
Not in determining whether the face of the award contains error. The standard of review is it's clear to the four corners of the agreement. The alternative bases upon which this court could overturn affirming an order, entering an award beyond the arbitrator's charge and applying it to parties that were not before the arbitrator, the court could look at the record outside of the four corners of the award.
Right. And so I suggested to your opposing counsel that if the award were confirmed, it would seem like at least one approach would be to confirm it as to Airbnb travel and then let you all litigate in the trial court whether that's sufficient to bring in, I don't know what phrase, alter egos, sister companies, piercing the corporate veil issues. They really just haven't been litigated. But I don't see the change from Homespace to McElrath as problematic.
I think the larger problem is that McElrath was permitted to advance 3 separate arbitrations. It is not in the record before the court, but the other 2 arbitrations that were held in abeyance pending resolution of the travel claim have now moved forward, and we have substantive decisions in those.
Right, and I would assume those would pop up shortly in the Superior Court once this case is remanded. And that would answer the question of can we pick up Airbnb Inc. and Airbnb payments. But I'm not sure that issue's before us.
I would agree. I don't believe it is before you, but I don't believe that it makes sense to allow injunctive relief that is brought against 4 separate entities to proceed against a single separate entity. That's not the way the claim is phrased. That's not how the arbitration award conceptualizes of what is happening here. And so I think that it is something of an invented remedy to proceed just against that one entity.
Okay, but let me ask a question. Let's assume that we send it back. We reverse here. Are you saying that because there are these other two entities that have unconcluded arbitrations, we can't have the trial court confirm the award even as to Airbnb travel? Are you saying we should just grab the bull by the horns and have the confirmation as to all three or even all four?
I'm saying that the way that the award is framed, it is not just as to Airbnb travel. So we are asking the Superior Court to confirm an award that does not exist.
Okay. Thank you.
Thank you, Your Honors.
So why not send this back
Send it back to who?
to the arbitrator?
To the arbitrator. I think that would have been somewhat reasonable, Your Honor.
Why do you say would have been? I'm suggesting that perhaps what we could do is vacate the Superior Court's order, remand it to the Superior Court to seek clarification.
To the arbitrator.
Yeah, by the arbitrator. And there's case law supporting that approach.
Yes, there is case law supporting that, but I think that we need
And
to,
you chose not to avail yourself of that, or are you availing yourself of it now?
I would certainly avail myself of that before seeing it vacated in full.
Right.
But I don't think that's the correct course here, because we have to look to the standard that this court should apply to determining if it should vacate that award. And if the award is even arguably correct, the arbiter's rulings should stand.
Yeah,
The
so
cases-
we looked at that. It's the issue of, like, is there a presumption here? So, like, we presume statutes are constitutional, and we give the party challenging the burden to show otherwise. But, so, I'm not aware of a presumption that the award is valid.
There is. If you look at the Supreme Court, the most recent Supreme Court case, Oxford Health, it says that it's not enough that the arbiter simply committed an error, even a serious error, because the parties bargained for the arbiter's construction of the agreement. So it's even if you do find an error, that's not enough to overturn the arbiter. It has to be something where they're dispensing their own brand of industrial justice, I believe one case says. So it's not simply that the arbiter
Except
got it
that's what your
wrong.
opposing counsel would say happened here.
No, and it's obviously that's not correct, because you, as Your Honor has said, there is a rational basis for the arbiter's ruling. You can read that, there's two ways that you could, I fully.
It helps a
concede.
lot to put that little phrase in.
Yeah,
Comments required
yeah,
by
and
statute.
you know, if you look at the mainline rock decision, it speaks directly to what Your Honor was saying, that arbiters, by saying too much, they can get overturned. If they just simply said, here's the award, there's nothing on the face to overturn it. And that's why the legislature actually, in 2006, modified the standard for vacating to actually eliminate legal error as the ground for overturning an award. And
I guess another way to approach the question is, what's the harm of sending it back? Let's say we shouldn't. Okay, fine, we get it wrong up here too sometimes. But what's the harm here? And I'm going to read just the case into the record, Tolson, which is 108 WINAP 495. That's a 2001 case. We send back stuff all the time to trial courts for clarification. We don't know what you meant in this 404B ruling. We don't know what you meant by this, whatever it is. What's the harm?
the harm, the only harm is that it would be contrary to the law for the arbiter. But, you know, I believe that the arbiter here did apply California law, was doing his darn best to apply California law, and for that reason, his award should be confirmed. Thank you.
Okay. Thank you. We're in recess.